Another day, another limiting instruction, and for the first time, an admonishment of Miss Love in front of the jury. Hi, my name is Rochelle. I'm an attorney. Even though I'm an attorney, I'm not your attorney. This video is for entertainment purposes only, and this is not legal advice. Today we're talking about the direct testimony of Antonio Sledge, and we're specifically looking at the portion of his direct examination where Attorney Love makes an error and attempts to introduce evidence purporting that it was by Mr. Sledge when in fact it was not. In connection with this indictment, overt acts numbers 41 through 46 set forth that Antonio Sledge, along with other alleged members of YSL, participated in a drive-by shooting on or about August 28, 2015. As a result of this incident, Mr. Sledge was charged with aggravated assault with a deadly weapon and possession of a firearm by a convicted felon, amongst other charges. After being charged back in 2015, Mr. Sledge ultimately decided to plead guilty under Alford. So let's talk about what an Alford plea is. An Alford plea allows a defendant to plead guilty to a criminal charge in order to resolve the case while still maintaining their innocence and without admitting to the underlying facts in the court case. The Alford plea is simply an acknowledgement by the defendant that the prosecution has enough evidence to potentially secure a conviction against them if the matter is taken to trial. It benefits the defendant because it allows them to receive a reduced sentence in most cases than if they would have taken the case to trial. It is important to note that with an Alford plea, the defendant has maintained his innocence and has not agreed to any underlying facts surrounding the charge to which they are pleading guilty. An Alford plea is different than a normal guilty plea. And this is an important distinction because in the YSL trial, Mr. Sledge pled guilty, not under Alford, on December 28, 2022. In connection with his December 28, 2022 guilty plea, Mr. Sledge had to admit to a host of underlying facts to support his guilty plea.
Before you signed this indictment, did you have an opportunity to fully discuss the facts and circumstances of this case with your attorney, Mr. Wright, to your satisfaction?
Yes, Your Honor.
All right. Is there anything else in this indictment that you wish to ask me?
No, Your Honor.
All right. I'll note the indictment's been signed, the plea has been entered.
What's important is that during Mr. Sledge's direct examination, Attorney Love is attempting to solicit factual information about the April 28, 2015 drive-by shooting. Mr. Sledge is not very forthcoming, and as a result of that, Attorney Love attempts to introduce the factual allegations underlying the 2015 drive-by shooting using a transcript from the hearing where Mr. Sledge's Alford plea was accepted.
When you pled guilty on December 28, 2022, was that a blind plea or something else?
I think it was just a plea. It wasn't a blind plea, though, if I'm not mistaken.
For a regular plea, what do you understand to be the terms? In other words, do you know your sentence before you plead guilty with a regular plea?
I don't know, because before the blind plea, I knew my plea.
Why did you then distinguish for the jury that it was a blind plea?
It was, but I already knew the sentence. My lawyer had already aware to me that they was offering the same thing. They was offering the co-defendants what they had pleaded guilty before me.
Okay.
So when I pleaded guilty, my lawyer aware me that they was offering the same plea deal that they gave them, but in my plea deal, I told my attorney to I didn't want the probation. I just take the straight prison sentence.
Okay.
Yes, sir. All right, outside the presence of the jury? Okay. Yes? Yes. Okay.
The issue with Attorney Love attempting to read these facts into the record is that she's asserting these facts as if they were agreed to and are the statements of Mr. Sledge when accepting this guilty plea. However, because the plea was made under Alford, that is simply not the case. And so after Ms. Love finishes reading these statements into the record, the defense attorneys object, and the proceedings are halted so that the parties, the prosecution and defense team, can have a discussion with the judge about what the appropriate next steps are. Unsurprising to everyone, Attorney Steele requests a mistrial based upon the error made by the prosecution.
Your Honor, I have a motion for a mistrial. The evidence has just come out that two co-defendants who, to my knowledge, at least one of them is not testifying and has entered a guilty plea. That is a confrontation clause violation to Mr. Williams and the other people on trial. In addition, Your Honor, gave an instruction with the last line, and I know it was objected to previously, but I want to stress this, that if it's a prior inconsistent statement, it can be used against Mr. Williams and the other people. That was premature because I don't believe there's anything inconsistent as of now. And then the third reason I'm moving for a mistrial in the aggregate, Your Honor, is that the prosecutor uses and reads the statement of the then prosecutor, I believe it was the Honorable Mr. Bailey, who entered this plea and gave a factual basis. But she did not make it clear that the Honorable Derek Wright said on page 12 of this transcript to the same court that Mr. Sledge is tendering the plea under Alford, which is ALFORD.
Yeah, I'm seeing the same thing. And honestly, I thought that we were going to be dealing with the guilty plea that he took in this case. And yeah, that's problematic that this 2015 case is an Alford plea. And so I don't think that any of what I said with regard to admissions is actually true, even against this. I mean, he's saying he pled under Alford, and I don't know why the disposition sheet doesn't say that, but it is very clear that this is an Alford plea in this 2015 case. So
the judge gives Ms. Love an opportunity to be heard. And at this time, instead of conceding the mistake that she had made and admitting that because Mr. Sledge had made this plea under Alford, the factual statements that she read into the record should not have been read into the record. Instead of Attorney Love conceding the mistake that she made, she attempts to defend her position and attempts to connect the statements that were read into the record related to the April 2015 drive-by shooting to the statements that Mr. Sledge agreed to in his December 28th, 2022 guilty plea in the YSL trial.
go ahead.
Now, okay. Your Honor, given that 17875 refers to statements of prejudicial matters, which are not in evidence, and the factual basis given or read by the prosecutor in the plea in the 15 SC case, while containing details that are not contained within the factual acknowledgments of 22 SC 183-572, it contains, it's about the same act, which in the factual acknowledgments for this case, the defendant says occurred. He admits and acknowledges that he, Demekion Garlington, and Quindarius Zachary committed a drive-by shooting at this residence. and that they committed the drive-by shooting on behalf of YSL and to increase the notoriety, reputation, and fear of YSL, and that he admitted and was convicted of aggravated assault, participation in criminal street gang activity, and among other charges for his participation in the drive-by shooting referenced in sections 3, 4, and 5. And given that this evidence will be properly before the jury, our position is that these statements, the questions that I asked, which contains the factual basis, the assertion about the factual basis in the 15 SC case, would not be a prejudicial matter. Though the factual basis is not in evidence, the fact of the shooting is not a prejudicial matter, which mandates a rebuke.
Okay. Well, the fact that a co-defendant who may not ultimately testify and who you do not believe will testify has pled guilty.
I don't disagree that that should go, but that was not something that I.
No, I know. I don't think that you intended to elicit that, but yes, I'm going to give a rebuke. Ms. Love, I mean, that's just what it is sometimes to be the prosecutor in a case.
After a few minutes of arguing, it's clear that the judge is simply not buying what Ms. Love is selling, and she concedes that she will accept whatever instruction the court believes is appropriate given the mistake that was made. Now, as an attorney, I recognize that we are humans and we often make a mistake. I think in this specific instance, Ms. Love not conceding that, yes, this plea was made under Alford. Yes, there is a significant difference between the facts that Mr. Sledge agreed to in this December 2022 plea agreement and the factual basis that are set forth in this April 2015 related to this April 2015 shooting. And so we will have to correct that in front of the jury, and we will need to issue them a limiting instruction. I believe that her failure to admit her mistake and try to present a potential solution is the reason why Attorney Steele believes that these are intentional actions by Ms. Love, and it appears that they believe that she's not acting in good faith. I believe that Ms. Love's failure to acknowledge her mistakes when she makes them, and her attempts to assert that she's done everything correctly, is the reason why the defense team really questions her genuineness, and Attorney Steele no longer calls Ms. Love an honorable district attorney. So the judge ultimately decides that she's going to issue another limiting instruction to the jury in order to correct this mistake made by Mrs. Love, and she also admonishes Ms. Love in front of the jury for the first time, despite Ms. Love's request that she does not receive the admonishment. Let's take a look at what the judge has to say in front of the jury.
Instructions for you with regard to some of what you just heard. So I gave y'all an instruction that if this witness provided testimony that was inconsistent with a guilty plea admission, that you could accept that guilty plea admission as substantive evidence against any of these defendants. But then what we heard was that this witness pled guilty in 2017 to that being a part of that 2015 drive-by shooting. But and we heard kind of a factual basis that the prosecutor in that guilty plea had read before the court, or somebody had read before the court, as a part of what Ms. Love was asking questions about, and she was, kind of reading it from a transcript. All right, here's the thing, is that guilty plea, as I think you heard this witness say, He entered that because he believed it to be in his best interest to do that. And this gets into a whole lot of kind of legal terminology and legal concepts, but there are a couple of different ways that somebody can say, yes, I'm pleading guilty to a crime. And one of them is called an Alford plea. It's just named after a case called Alford. But they're essentially saying, I am going to plead and accept that I'm guilty of this crime, but I am not saying that the facts that the state's putting forward are true. I am just saying I think it's in my best interest to go ahead and resolve it that way. So everything that you heard is, and that is totally legitimate to do that. And let me also say that Mr. Wright, who was representing this witness at the time, he let the court at that time in 2017 know, hey, this is an Alford plea. He's doing this because it's in his best interest, he believes, to do this. And Mr. Sledge was under no obligation after his attorney said that to, even if he got an opportunity to say anything else, to say, yeah, what my lawyer said, to add anything whatsoever to that. So I think there was a question about that, and he didn't, he didn't say anything else. He had no obligation to, he had no requirement to, he had no responsibility to, okay? So basically what I told you about, oh, you can take those facts and those admissions and consider it against him or anybody else in this trial. When it's an Alford plea, you cannot. So none of that I said was actually true about what you just heard about those 2017 guilty plea to the 2015 drive-by shooting, okay? So let me think what else. Oh, and you also need to completely disregard that anybody other than this witness right here, Mr. Sledge, might have pled to anything that had to do with that drive-by shooting, all right? So just entirely erase that from your minds. And I also, at this point, am going to admonish and rebuke you, Miss Love, to pay careful attention to how you ask questions and to what you put before the jury. You should not have put that factual rendition before the jury as anything that this witness admitted to at the time of the 2027 guilty plea. And I'm going to instruct you to refrain from asking improper questions.
Yes, Your Honor. Thank you.
All right. Anything in addition?
Thanks for watching this video. Please don't forget to like, comment, and subscribe to the channel. If you have recommendations on other videos that I should do in the future, please leave a comment down below. Also, if there are other cases that you want me to talk about, please leave the names of those cases down below. See you in the next video.